focus the rest of the talk. Now, if the family is asking you to provide treatment that you think is medically and ethically inappropriate, maybe you can transfer the patient to another facility that's willing to provide this treatment, right? And then everybody's happy. You don't have to provide treatment that you think is wrong, and the family gets the treatment that they want. Often not possible to make such a transfer, but sometimes, and it should be tried if possible. If you can't transfer the patient, now you really have an intractable conflict. And what can you do now, right? Well, there's basically 4 options. You can take covert action. You can cave into what the surrogate is asking you to do. You can get a new surrogate, or you can just stop, meaning stop, withhold or withdraw without consent. Covert action. And what I mean by that is without legal support to withdraw or withhold openly and transparently, some do it covertly. And in what's probably still the most widely cited study on this by Ash, 14% of responding physicians said, on the basis of futility, we withheld or withdrew life-sustaining treatment, not only without the consent of the family, but also without even the knowledge of the patient or family. Right? And this is probably not a good idea. This harkens back to the purple dots in the New York hospitals of the early 1980s. Probably the most dominant approach is to cave in, right? And when physicians asked, why did you follow the substitute decision maker instead of doing what you felt was medically and ethically appropriate? Usually the reason is a lack of legal support, right? Because they're afraid there's this threat, whether it's explicit or just implicit, from the surrogates, which is remove the fill in the blank, ventilator, dialysis, and I will sue you. So proceeding to do what you think is medically appropriate appears risky, like crossing this little rickety old bridge, while caving into the surrogate appears a safer course of action, like crossing this nice, sturdy steel bridge. Now, to be sure, there is some legal risk. It's not settled law that in the event of disagreement, the physician has the final say. There is some exposure to civil liability, battery, medical malpractice, informed consent. There's even possible exposure to discipline from the medical board or even criminal liability for homicide. That said, physicians have won almost every single damages case that's ever been brought for unilateral withholding, withdrawing life-sustaining treatment. The only types of cases that physicians have lost have been claims for intentional infliction of emotional distress. So basically what they're being sued for, the gist of the claim is not for unilaterally withholding without consent. It's for doing so in a secretive, insensitive, and outrageous manner. It's worth noting, though, intentional torts are typically not covered by insurance. Do we know who this is? So this is Jocelyn Dickoff, okay? So the one thing that changed in Minnesota this year is prior to 2013, in a medical malpractice suit, you had to establish causation, right? So so take a unilateral DNR order, right, for somebody who's very elderly, inpatient, or with metastatic cancer. It would be very difficult to ever win that claim because it would be impossible for the family to ever establish that had you provided CPR, it would have worked, right? You unilaterally wrote a DNR order, what probably wasn't going to work anyway, even if we had done it, right? So they could never establish causation, that your unilateral order made any difference. Probably was going to not work anyway. What the Minnesota Supreme Court said this year in the Dickoff case is you can sue for lost chance, right? So if there's only a 10% chance a CPR was going to work, you can sue for depriving us of the lost chance, right? You didn't do CPR, we didn't consent to that. In the old world, you'd have to prove that it would have made any difference. Now you can just sue and say, oh, you deprived me of a 10% chance or a 5% chance. So take some comfort. Generally, medical malpractice attorneys don't take claims worth less than $250,000, and that's probably a low. That's probably should be higher than that, but I take a low figure, right? And therefore, these claims generally aren't ever going to be brought for practical reasons, even if you can actually make out the legal claim. The patients we're talking about are really obviously really close to that. The claims aren't valued that much because the way in which we value medical malpractice claims is in terms of lost wages. These people probably weren't going to earn any more wages, so the claims just aren't worth enough. These claims, you would have to make a big investment, and you're not going to get a return on the investment as a plaintiff's attorney to justify that investment. Moreover, generally, in any world, good documentation, good charting deters malpractice claims. And if you follow your own futility policy, it's basically just more charting and more documentation, not only by the attending physician, but also by all these other independent opinions and committees. It basically is more charting, more documentation, more likely to deter because it looks like a careful, deliberate process was followed. That said, there are entities out there that don't care about whether or not this claim is going to pay off or not. They're out there to bring these lawsuits just to make a political point. So that all said, the risk is really, really, really low, but it's probably greater than zero. Moreover, clinicians aren't just liability averse, they're litigation averse, right? The process is itself punishment because even prevailing parties pay transaction costs in terms of time, emotional energy, and so forth. And so it's just easier to cave in. The patient's going to die soon. The provider's going to round off, and the nurses bear the brunt of it. So this is, in one sense, just another species of defensive medicine, right? Overwhelmingly, majority of physicians say, I agree or strongly agree with the statement that I provide treatment solely for legal reasons, not for medical reasons, right? This is actually a sort of disturbing survey from the Journal of the American Geriatric Society, that some reporting physicians said that concern that the surrogate might sue is a factor driving the treatment that's more important than the patient's prognosis, more important than what's best for the patient, and more important than what the patient would want, right? Concern that the surrogate might sue is the most important factor driving my decision. Okay, so you have now a surrogate that's asking you to do something that you think is medically and ethically inappropriate. Well, you need consent, can't get consent from this surrogate, get a new surrogate from whom you can get consent. Surrogates are supposed to act and exercise substitute judgment and make the decision that the patient would have made for herself. And if you don't know what that is, then at least make the decision consistent with the patient's best interest. This is codified in the statute. In Minnesota, we call it the duty of good faith. Unfortunately, surrogates aren't so good at this, right? And there's a lot of studies on this, that the accuracy of surrogates is only about 60%, right? Barely better than chance, right? So surrogates aren't too accurate in exercising substituted judgment. And when they make this error, so there's a high rate of error, the error leans all in one direction, which is surrogates are overwhelmingly make more aggressive treatment decisions than the patients would make for themselves. Now, I'm not suggesting we just rush out and replace surrogates. You know, they're having a tough time, they're playing a new job for the first time. We should try to help them, right? We should encourage surrogates, before they become surrogates, we should encourage people to talk with their families about their healthcare preferences so the families can make better decisions. And there's tools for training surrogates on what it means to be a surrogate and what that job is and how to play that role. There's the ABA, American Bar Association, publishes a book that you're allowed to customize for your state and then republish, which Vermont and some other states have done, called Making Decisions for Someone Else. But if the surrogate persists in making a decision that's inconsistent with patient preferences or best interests, they can and should be fired, right? They should be replaced. And this happens a lot across the country for several reasons. One is, obviously, if there's a material conflict of interest. Financial, there's a case, the Baby M case up in Edmonton, where the parents had beaten the little baby into a person's vegetative state and then refused to consent to the recommendation to withhold life-sustaining treatment. But of course, the concern was that the criminal charges would be escalated to murder, right? They suffered a conflict of interest. They were replaced as the decision makers. Another situation in which a surrogate should be replaced is where what they're asking for is inconsistent and contradicts the patient's own advance directive, right? The surrogate is saying go, but the advance directive says stop, right? Remember the Al Barnes case, right? His advance directive, the real advance directive, the one that wasn't forged, said was applicable and clearly declined the treatment that he was getting in those circumstances. But his wife, Lena, insisted that clinicians continue to provide the treatment that he himself, by his advance directive, didn't want. so she was replaced with a professional guardian. Happens across the United States all the time. Barnes' case isn't unique. In New York, Dorothy Lovatis' daughter, same thing, asking for treatment that was inconsistent and contradicted her mom's advance directive. There's a daughter. She was replaced with a professional guardian. Even when you don't have a contradiction between the surrogate and the advance directive, but just a contradiction between the surrogate and what is understood to be the best interest of the patient, surrogates are replaced. In New York, Gary Harvey, his wife was replaced because the court found that she, quote, failed to follow medical advice, failed to use good judgment. At the Mass General, Barbara Howe's daughter was replaced. The court told her, your own personal issues are impacting your decisions. I urge you to refocus your assessment. Another more recent case in Reading, happens all the time. And in fact, the AMA Code of Ethics tells us that though the surrogate's decision should almost always be accepted, situations may require institutional or judicial review. So Stephen Stills said that, you remember the song, right? If you can't be with the one you love, then love the one you're with. That may or may not be good advice with respect to romantic relationships, but it's not good advice when it comes to surrogates, right? The surrogate that you have, the one you're with, may not be the right one. And as the burden-benefit ratio gets higher, really the surrogate should have better evidence that this is really what the patient would have wanted. And in fact, sometimes some facilities have gotten into trouble, have been successfully sued for failing to replace a surrogate when the surrogate is clearly acting outside the scope of their authority. Now, there are some real limits to surrogate replacement as a dispute resolution mechanism for futility disputes. One is, it's hard for providers to show any deviation between what the surrogate is asking and what the patient would have wanted because so few people do adequate advanced care planning. We don't know what it is that the patient would have wanted, so how do we know that the surrogate is deviating from that, right? Another one is that the surrogates generally get the benefit of the doubt in any case, right? So if they're way off, then maybe they can be replaced. But if in the finer gradations, it's not clear that you have a good case to replace the surrogate. So even today, right, if you had a case like Helga Wangley, a famous Minnesota case, it's unclear that Oliver Wangley would be replaced as his wife's surrogate. She was in a person's vegetative state. She wasn't suffering. It's not clear that he was really acting outside the scope of his authority. But the biggest limitation on surrogate replacement as a dispute resolution mechanism is that many times surrogates are faithful. Right? Let me just take you up to Ontario for a second. In Ontario, they have a special tribunal, quasi-judicial tribunal called the Consent and Capacity Board. And it replaces, in medical futility disputes, surrogates all the time when they're failing to act according to the appropriate decision-making standards. There's a case, Hassan Rassouli case. He's been in Sunnybrook in Toronto for 3 years. And providers thought that in a persistent vegetative state, providers thought, well, this, it's not appropriate to continue. We can't really provide him any benefit. But they did not go to the Consent and Capacity Board. There's this whole tribunal specifically set up just for this situation. And why? Because they would have lost, right? The reason the family, Hassan Rassouli's family, was asking for continued treatment was because of his Muslim faith, right? They were loyal, faithful, good surrogates, right? They couldn't be replaced. They were making the same decisions the patient would have made for himself. And so you have lots of religiously motivated treatment. Hard surrogate replacement is not going to work as a dispute resolution strategy. So you have a surrogate, they won't consent. You can't get a new surrogate to give you consent. Then what can you do? Well, you're going to have to stop without, either you cave in or you stop without consent. So now I'm all the way but the bottom, right? Because remember, we started only 5% were intractable. Most of the 5% of intractable can be resolved through surrogate replacement. So now we're down to just a subset of the 5% of intractable conflicts. And here, what are your legal options? Can you stop life-sustaining treatment without consent? And what I like to do to describe this, to summarize the legal situation in the United States, is to use a traffic light, red, yellow, green. And by red, what I mean is, no, you can't stop without consent. You need consent. You always need consent. Hassan Rassouli's case went up to the Supreme Court of Canada just a few weeks ago. That's what the Supreme Court of Canada said. In Ontario, you always need consent. Can't get consent, you can try to replace them at the Consent and Capacity Board, but if that doesn't work, you're stuck, because that's your only option. You always need consent. New York, same thing, right? New York says if the surrogate directs life-sustaining treatment that the provider does not wish to provide, you shall nonetheless comply. Last year, Idaho enacted a new law called the Discrimination and Denial of Life-Preserving Treatment Act. What does that say? It says healthcare may not be denied if it's directed by a surrogate, right? Red light. You need consent. Oklahoma, same thing. And Alaska and a couple other states have been considering similar legislation. There's another red light, which is worth mentioning, which is generally in any state, the surrogates can go to court and get a temporary restraining order or injunction saying, look, I think they're going to unplug my loved one, and the judge will say, well, okay, it's going to want it as a stopgap measure just to preserve the status quo until we can figure out what's going on here. The problem, of course, is that the judicial process is so slow and cumbersome that by the time we have a hearing on the merits, the patient's probably going to be dead. So basically, it's a de facto red light. Judge never said that they had the right, but just as a stopgap measure, de facto, they won. Another red light, well, let me talk about this one because this is Minnesota, right? So Minnesota is, I think, best characterized as being a partial red light state. So we have this statute, the Healthcare Directives Act, in Chapter 145C of Minnesota statutes. But the one that's of interest with respect to medical futility is 145C15, which says a healthcare provider who's unwilling to provide directed healthcare that in reasonable medical judgment has a significant possibility of sustaining the life of the patient shall take all reasonable steps to ensure the provision of the directed healthcare until the patient is transferred. So if you're unwilling, but the treatment will work, it can sustain the life, right? So dialysis for a PVS patient, it will work. It might not be worthwhile, but it will work physiologically. Then you have, if you can transfer, great. But until you transfer, you have to keep providing that requested health care, right? So this looks like a partial red light. And in fact, that's what it was deliberately intended to do. If you go back and look at the legislative history, this woman who's the lobbyist for this entity called Minnesota Citizens Concerned for Life, they gave this section to her basically during the legislative process to get, so she wouldn't oppose the rest of the Healthcare Advance Directives Act statute. It's worth noting that, like I say, it's a partial red light because the statute only applies to one type of surrogate, right? Agents, people who are appointed in an advance directive as a durable power of attorney for health care, right? If you're a default surrogate, just next of kin, just a family member who's not appointed, the statute doesn't apply to them, and it's clear from the legislative history it wasn't intended to apply to them, and it doesn't apply to guardians, right? And so these are most of your surrogates, so it's a partial red light, but fortunately the scope is limited. So at least with respect to most of your surrogates, you don't have a red light. It's only red with respect to agents. It's not red. It's not green either, right? In Minnesota, it's yellow, right, for the rest of the surrogates, which is what it is in most states. And what I mean by yellow is it's not clear, right? Generally, you don't have to provide health care that's requested if it's, quote, inconsistent with generally accepted health care standards. The problem is we don't really know what are the generally accepted health care standards when it comes to ICU level treatment. It's not even clear there are any, right? There's enormous variability among clinicians as to what's considered to be medically appropriate with respect to ICU treatment. Lots of studies, we have shown this high level of variability, inconsistent ideas about what's appropriate in different sets of circumstances. The only thing that we seem to have consensus on is brain death, anencephaly, babies under 22 week and under gestation, and pure physiological futility. What physicians want is a safe harbor. Unfortunately, to be effective, a safe harbor has to be clear, precise, concrete, and certain, and we don't have that kind of clearness or precision or concreteness. If at best the safe harbor or the harbor might be called mind. Because physicians are still worried about the legal consequences of withholding or withdrawing without consent. What's a little bit worse even is that by continuing to provide treatment that they think is inappropriate, like continuing to provide dialysis for somebody in a vegetative state, they're actually continuing to create and reinforce the very standard of care with which they don't want to comply. In this month's December 2013 Virtual Mentors, a publication in AMA, the physician authors observed that there's a general, if unofficial, consensus among most intensivists that surrogate requests be granted, even when patients are irreversibly ill and will not survive. And so as of right now, right, at least with respect to CPR, dialysis, mechanical ventilation, and artificial nutrition hydration, it's not quite clear what the generally accepted healthcare standard is. At least with some aggressive organ replacement therapies like ECMO and ELAD, right, people are more comfortable, clinicians are more comfortable that these are outside the standard of care, and we feel more comfortable unilaterally refusing these treatments. But now there's actually a concern that ECMO, for example, is starting to be used in, less as a bridge therapy and sometimes as a destination therapy. And so what is the standard of care with respect to ECMO is becoming eroded, in the same way that these have. And it's worth noting, right, that it's rather remarkable in the United States that of all of the actors in the United States, right, the medical professionals get to set their own standard of care, right? If you sue an architect, you sue an airplane pilot, the fact finder, the judge or the jury gets to think, what should they have done? What should that airline pilot have done? What should that architect have done, right? A judge or jury never gets to ask that question when you're suing a healthcare professional because they get to set their own standard of care. You don't get to make that normative judgment of what you should have done. They tell you, this is what we do. This is our custom. So they're only measured against the custom that they create for themselves. So at one level, I guess what I'm saying here, at least with respect to medical futility disputes, you might say that since you get to set your own standard, you didn't set one, so you sort of dropped the ball. That's probably not fair. But that's where I'm going, is that the recommendation is that the standards be clarified. I think there's some professional associations are doing that, and they're starting to clarify what, through clinical practice guidelines, what in fact are the appropriate standards for use of some of these therapies. So let me just end with this. What people want is a green light, right? And the one green light we have in the United States is Texas, right? Where the Texas statute says if you can stop life-sustaining treatment for any reason, so long as your ethics committee agrees with you, right? You have to give the surrogates 40 hours notice of the ethics committee meeting. You hold the ethics committee meeting. They vote, usually agree with the referring physician. You give the family 10 days to try to find another facility willing to provide the disputed treatment. And on the 11th day, you can unilaterally withhold or withdraw. And you have civil, criminal, and disciplinary immunity, and there's no appeal to the courts of the ethics committee's decision, right? It's been used a lot over the last 14 years, and that's why it's been perceived as being a model. Lots of other states have tried to copy the Texas legislation. At the professional association level, California Medical Association, Washington, even Wisconsin, all passed resolutions to copy Texas. At the legal level, all three branches of state government have explored this. In Idaho, the Idaho Senate passed a bill modeled on Texas. In Maryland, they tried to do it through agency regulations at the administrative level. And in New Jersey, the Hospital Association and the Medical Society asked the courts to give them a Texas-type rule. Those all failed. Texas remains alone as the only green light state. But there's another green light, and that's the conscience-based objection clauses, right? These are passed a lot in the reproductive rights area, but they're written broadly enough to cover all health care, right? Normally, there's a condition on conscience-based objections, which is you can stop on the basis of moral objections, but you have to continue to treat until you could transfer the patient to another healthcare provider. But it's worth noting that a lot of states now have dropped that condition or limitation on conscience-based objections, like Mississippi, Nebraska this year, Michigan this year, Kentucky this year, and other states are considering it. In other words, you don't have to make a referral and you don't have to transfer. If you have a conscience-based objection, you can just stop, right? You heard a few days ago the ACLU suing the National Conference of Catholic Bishops for similar issues. One other green light, in Maryland and in Vermont, the POLST regulations allow you to write a POLST, the DNR order of a POLST, instead of on the basis of patient or surrogate consent, on the basis of medical futility. So let me actually, since I see where I used up most of my time, maybe I'll just skip the ATS policy. Maybe it's just worth mentioning that there is a policy being developed, multi-society, with American Thoracic Society, Society of Critical Care Medicine, American College of Chest Physicians, American Association of Critical Care Nursing, and the European Society of Intensive Care Medicine to update, because a lot of the existing model futility policies from the AMAs from '96, ATS is from '91, so it's basically update a model futility policy because all the existing ones are getting a little bit dated. But I'll stop here just to make sure we have time for questions.